4-part series on qualified immunity. If you notice on your tables, you have some cards, some pens, and we want to encourage you, if you have any questions, to write your questions down, and we'll get those questions and we'll get those answered for you. My name is Jonathan McClellan. I'm a graduate of UST Law School and also the president of the Minnesota Justice Coalition. We are part of a collective of organizations that work with families and community to draft and advance legislation and other policy initiatives at the Capitol in St. Paul and in Washington, D.C. We also provide education to the community on these important topics. We are the home to the Reinvestigation Workgroup, who is a Minnesota-based investigative team that re-examines cases of police violence after the official investigation is over. As we gather here today, I want to acknowledge that we are approaching a deeply significant moment in our collective history, the 5-year anniversary of the murder of George Floyd on May 25th, 2025. That moment in 2020 was a catalyst not only for global protests and conversations, but also for meaningful action. In the aftermath of George Floyd's death, I founded the Minnesota Justice Coalition with one guiding purpose: to bring healing through justice by harnessing the power and responsibility of the legal profession, leveraging the will of the people. At Minnesota Justice Coalition, our mission is to serve our communities by advancing social justice, racial equity, restorative justice, and legislative reform, all while working to restore trust and offer pathways to healing within the justice system itself, providing education to the community and building coalitions. Our ethos is simple but powerful: transparency, accountability, and justice. This work did not begin for me in 2020. I've spent most of my adult life in the trenches supporting other organizations, community advisory boards, and politicians. But over time, I began to feel that some efforts weren't addressing the root causes of systemic injustice. That realization pushed me to take the leap and create an organization rooted in advocacy, education, and action. The Minnesota Justice Coalition is the result of that vision, a vision not just for change, but for transformation. In 2021, the Minnesota Justice Coalition drafted and advanced the legislation in Minnesota around ending qualified immunity. The purpose of our event is hoping to pass the Minnesota Civil Liberties Act, drafted by Minnesota Justice Coalition, which would create a state-based civil remedy that expressly prohibits qualified immunity. We have an all-star panel tonight. I would like to thank everyone for joining us, and to the University of St. Thomas School of Law for hosting us. Thank you for being here today and for being a part of this journey. Together, let's continue pushing for the kind of justice that not only speaks, but heals. Our goal tonight is that each of you walk away with a knowledge of the subject. If I forgot something during my introductions, charge it to my mind and not my heart. Our two moderators tonight are Emma Peterson, who is a member of the Reinvestigation Workgroup and the Director of Policy for Minnesota Justice Coalition. She is Minneapolis native. She is a 1L at Hamline School of Law and also earned her master's in public policy from the Humphrey School at the University of Minnesota, with a thesis on how police associations shaped Minnesota's deadly force policy. Our other moderator is attorney Paul Bosman, a dedicated advocate for individuals and communities in Minneapolis and across Minnesota. He currently serves as a prosecutor in southern Minnesota while continuing to work closely with communities in the pursuit of justice. With a background in civil rights, bankruptcy, and Minnesota data practices law, Paul brings a unique blend of legal expertise and a deep, unwavering commitment to justice in every case he takes on. As the former chief counsel for a local nonprofit organization, Paul has extensive experience advocating for accountability and transparency in law enforcement. His passion for justice extends to his work as a board member for the Minnesota Coalition on Government Information, where he continues to promote access to public data. Paul is a graduate of William Mitchell College of Law. Prior to law school, Paul worked as a donor acquisition for data management officer at the Alina Health philanthropic entities. Prior to his 10 years with Alina, Paul worked for New Jersey Environmental Federation, Minnesota COACT, Minnesota Clean Water Action, Montana's People Action, Idaho Citizens Network, Washington Citizen Action, Oregon Fair Share, and Campaign California. Paul is also a former U.S. Army infantry officer and a military parachutist. Our three panelists tonight are Professor Jim Hilbert. He is currently a professor of law at Mitchell Hamline School of Law, where he has taught full-time since 2010. He is a former interim president, dean, and former vice dean at the law school, and currently also serves as senior fellow at the Dispute Resolution Institute. He teaches transactions and settlements, civil rights, education law, expert witness advocacy, deals in disputes resolution, and international business transaction. He is a longtime executive committee member of the St. Paul NAACP. He is also ad hoc counsel for the state NAACP. In addition, Professor Hilbert is the co-director of the Expert Witness Training Academy, which is funded by the National Science Foundation and provides training to etymologists on communicating in courtrooms and legislative hearings. Professor Hilbert's scholarship covers police reform, state constitutional law, school desegregation, expert witness testimony, and negotiations. Before joining the Academy, Professor Hilbert was a civil rights attorney for over 10 years and a former legal fellow at the Institute on Race and Poverty at the University of Minnesota Law School. Professor Gregory Sisk. Professor Gregory Sisk brings a distinguished background in public service and legal scholarship to his work at the University of St. Thomas School of Law, where he holds the Pio Cardinal Laghi Distinguished Chair in Law. His career spans all three branches of the federal government, having served as legislative assistant to the U.S. Senator, a law clerk on the U.S. Court of Appeals for the Ninth Circuit, and as an appellate specialist with the U.S. Department of Justice. Following his time in government, Professor Sisk led the appellate department at a Seattle law firm, developing an extensive litigation portfolio that includes arguing cases before 10 of the 13 federal courts of appeals, as well as multiple state appellate courts. A nationally recognized scholar, Professor Sisk is known for his work on civil litigation involving the federal government and for his groundbreaking empirical research on judicial decision-making. He also writes on federal courts, legal ethics, and constitutional law. His scholarship includes a widely used casebook, Litigation with the Federal Government, and a companion treatise. His empirical research was honored with the Article Prize from the Law and Society Association. Professor Sisk remains active in legal practice, primarily in appellate advocacy, and as a consultant and expert witness on legal ethics. He has briefed cases before the U.S. Supreme Court, particularly on issues involving civil suits against the federal government and jurisdiction in the Court of Federal Claims. He also served as a reporter for the Iowa Supreme Court's committee tasked with drafting the Iowa Rules of Professional Conduct. An elected member of the American Law Institute, Professor Sisk teaches courses in professional responsibility, civil procedure, appellate clinic 2, and supervised legal research in writing. He also played a central role as primary testifier in efforts to end qualified immunity in the state of Minnesota. In addition to his academic and legal work, Professor Sisk is the author of a novel, Martial Privilege, published in 2014 by North Star Press. Chad Reese, and our final panelist, is an assistant director of activism at the Institute for Justice. The Institute for Justice is a nonprofit public interest law firm. Their mission is to end widespread abuses of government power and secure the constitutional rights that allow all Americans to pursue their dreams. Chad is a legislative and advocacy consultant. He provides full support for policy campaigns, from grassroots organizing and issue identification to municipal and state level lobbying services. Chad also provides communication services from campaign strategy to individual messaging and skill-based training. Chad has his master's degree from George Mason University and a BA from the University of Kentucky. We look forward to a thoughtful and engaging conversation tonight, and with that, I'll turn it over to our moderators, Emma and Paul.
All right, thank you so So we're going to get started with the panel tonight. We want to first thank you all for being here. We also want to thank our independent media. Thank you so much to King Demetrius Pendleton here.
All right. Yes. Solidarity.
He is an independent photojournalist, and he's been really on the ground documenting the movements in our city and in our state for, I think, 10 years now. Actually.
Yes. Or more.
Yeah, he also owns a studio, listen to a studio that's over George Floyd Square. So if you guys are in town and want to visit, please visit the studio and help support the studio. So
His photography is amazing. Hangs on my office wall.
Thank you. Solidarity.
awesome. Well, thank you, and thank you so much for our panelists for being here. We're gonna get started, and we're gonna first open up the night. We're gonna start talking about civil rights. What is civil rights litigation, and how does it relate to qualified immunity? So we're gonna jump in, and I'm gonna first hand it over to Professor Hilbert. If you could just kind of start off with an overview of what's called Section 1983 litigation, and teach people about what that is.
Fantastic. Thank you, Emma. Thank you, Paul. Thank you, Jonathan. I think this is my third event that I've been to that the coalition and students have set up. And I just want to say before I begin, I appreciate the work of keeping the issue of police reform foremost in our minds, even while we think about all the other things that are happening in the world right now. This issue is extremely important, and I know we've got families of victims on Zoom with us, and just a special shout out and greeting. Really appreciate all the work that's been done. I will share with you, if you know Emma Peterson, you know how organized she is. And
Yes.
in advance of this panel, she put together a very detailed listing of the topics she wanted us to cover, which was extraordinarily helpful and appreciated by me, because part of the discussion about police reform sometimes misses the history of what is the quintessential, most important civil rights statute we know, which is Section 1983. We're going to talk about qualified immunity, and even if you've been not paying attention, or if you've only spent a little bit of time thinking about police reform or a little bit of time in the federal courts, you've probably heard of qualified immunity. It is this enormous blockade between people seeking justice and remedy in the court. And what's scary about qualified immunity, and you're going to hear a lot more about it from our expert, Professor Sisk, in a little bit, but what's scary about it at the foremost here is that it is growing. It has been around a long time, and it has reached the point where nearly every single 1983 action is prevented by this enormous defense. So what is Section 1983? And this is the part I like so much, Emma, is you asked us to look back at the history. Where did we start? I was afraid you were going to make me leave.
Just as long as I've got it.
Yeah, all right. 1871, the Ku Klux Klan Act. That's where we get Section 1983. And it's important to think about the context. So 1871 was the beginning of a part of our country that reminds us that our country goes through cycles. Cycles of repression, cycles of regression, but sometimes cycles of reconstitution, reconstruction, rebuild. And if you're feeling like I am these days about the status of our country, sometimes it's helpful to think back and realize that repair, restoration, and reconstruction are part of our fabric, and the cycles return. So 1871, Reconstruction. The Civil War had ended. The 14th Amendment had been passed. But the status of our country was terrible. In fact, President Grant called on Congress and said, we have to do something to stop this violence that is ripping apart the South. The amount of violence and murder and abuse is hard to discuss in the time I've been given. But it's important to remember that time, because that's why Congress passed Section 1983. And in fact, the bill itself contained not only Section 1983, just to give you a sense of what they were up against, it also included things like suspending habeas corpus. That means imprisonment without due process. Allowing, authorizing martial law, permitting the use of federal troops to police the states. The Ku Klux Klan was running rampant, and Congress acted. Section 1983, a part of that bill, basically said that anybody whose constitutional rights are violated by someone acting under color of law had a court remedy in federal court. And they said very explicitly this under color of law because it wasn't just the Ku Klux Klan. Sometimes it was police officers or state officials. And they wanted a mechanism for justice for people so that they could get into federal court and adjudicate their rights. Now, part of why this history is important, part of why we think about Reconstruction, a time, by the way, that we don't spend enough time on in our history classes. But this was an effort, a legitimate effort, and if you think about the relative progress that was made, it's pretty impressive. Yes, we were decades away from the 19th Amendment. It wasn't perfect. But in terms of trying to establish a multiracial, inclusive democracy, it was a pretty impressive period of time. And 1983, Section 1983 was a big part of that. So thinking about that, we have legislative history, the statements of the people writing the law, who talked about how this law is meant to be broad. It is meant to remedy in broad strokes. It had a very important mission, which makes qualified immunity all the more frustrating, because this law was meant to be a powerful balancing of power. Again, Reconstruction, multiracial democracy. So what do we know about what happened between 1871 and today? And part of what I'm going to talk about is the first several decades. So, as you know, Reconstruction didn't last very long. And by 1877, the compromise that answered the question of a presidential race that was in question led to essentially more blowback. And the courts began to dial back in terms of their civil rights enforcement. So while promising and powerfully written, Section 1983 was barely used. In the first 50 years, 21 cases or so. And part of what's confusing about that time frame, and it comes up a little bit, and we'll talk a little bit more about it when we get into qualified immunity. The statute itself is clear, and it doesn't include anything about immunities or defenses. And if you read the legislative history and you think about the context, that makes sense. They were trying to undo something extraordinarily difficult. But if you think about the court cases from that era, Section 1983, of course, wasn't the first time that people could bring constitutional violations to court. So the question is, well, how were those resolved? And it's a little hard to know. I mean, this is a long time ago. But generally speaking, there weren't these blanket immunities that were already available in court. There were two exceptions. Prosecutors and legislators were granted absolute immunity generally for a long time. And those were there. And the reason this is relevant is because if you ask yourself, if Congress intended to have something like a qualified immunity defense, if it intended to have some way of providing a major obstacle, it would have said so. And if it didn't say so, then maybe there were things in the history, in the court cases of those days, that suggest, well, Congress knew that those were there, so it didn't have to say anything. And so, looking at that history, we can say, no, actually, there weren't. I mean, there were some tort immunities that would come up, as those law students know. False imprisonment, for example. There's a good faith requirement. If I arrest, as a police officer, if I arrest somebody for a crime, for a law that is later overturned, that's a good faith defense. And that kind of an immunity was probably built in. Congress knew it was there. It was fairly well established. But there was no blanket immunity. And so, Section 1983, barely used. There was one case, and this is a little obscure, but there was a 1915 case, Myers versus Anderson, where the court was confronted with the question of immunity. It's the first time they have to actually answer the question, what kind of defense is available? And they don't spend a lot of time on it. It's not a deep discussion. But the court clearly says it doesn't apply. We're not going to worry about immunity in this status. Why? Because we're trying to adjudicate constitutional rights. And the court in 1915, not that far away from 1871, understood the impact and the power. And so that was the first time the court thought about it. But generally speaking, 1983 was underutilized until the late 50s, Chicago. Famous case, maybe students have heard of it, Monroe v. Pape. And this is the case, historically, that launches the real era of Section 1983. And the reason I say Chicago in the late 50s is because just like the original drafting of Section 1983, context matters. And in the late 50s in Chicago, the police and the black community had a terrible relationship. The police were essentially a tool of the racial hierarchy, just in similar fashion that back in its era, 1871, the Ku Klux Klan was a tool of white supremacy in that era. And the facts of Monroe v. Pape matter. So, Chicago, police tension, lots of racism. Chicago, one of the most segregated cities, and still that way in the 1950s, frankly still that way today. About 1 mile from the boundary between one black community and one white community, a white man, father of 3, was murdered in his home. And the police are called, and the police are told by the victim's wife, 2 black men broke into our house and killed my husband. So she goes down to the station, she looks through the mug shots, and she identifies James Monroe. James Monroe had a criminal record, had previous burglary criminal record, and so she says, oh, that's the guy, that's one of the guys. So the police, no warrant, break into James Monroe's home. James Monroe, his wife, his 6 children are in an apartment. The police pull them out of bed. They're not wearing clothes, they're standing in front of their children. The police are using every racial epithet in the world. They're abusing the children, they're abusing James and his wife, and then they haul James off to prison, or to jail, where he spends the next day without charges. Now, the facts matter in this case. By the way, there's a bizarre twist to this case, and I mean, you won't be surprised to learn this, but it turns out that the wife was having an affair, the man she was having an affair with was the true murderer all along. And to the police's credit, they figured this out eventually. So James Monroe was released. But James Monroe brought a case under Section 1983. The ACLU called him and said, hey, what happened to you is illegal. We've got this claim, 1983 case. They go to court. And by the way, the judge was Julius Hoffman, the trial judge in the Chicago 7 trial. Sort of ironic connection. But the judge there says, well, wait a minute, this is 1983 is not meant to cover illegal activities. The police are acting, they're not acting like police. They're outside their authority. This doesn't count for 1983. And the circuit court agreed. The Supreme Court, Warren Court, 1961 gets this case filed and says, no. We've read the legislative history. And if you read the Monroe decision, it's replete with all these quotations from the legislators and how important this statute was. And it talks about the history, and it talks about fighting the Klan, and it talks about trying to establish, not in these words, but in the words of the era, a multiracial democracy, a truly inclusive democracy. And the Supreme Court says, no, this case counts. Under color of state law means anybody who dresses like a cop, shows up like a cop, even if they are not acting like a cop should, this statute covers, because this statute's important. Well, that decision changed everything. And we had, from 1961 on, a 1983 case that we could use. Section 1983 became probably the most important civil rights statute from that day forward. Until the court began to dial it back. And you may hear more about this. I'll set the stage and then I'll turn it over. 1967, in a case called Pearson v. Ray, the court confronts a slightly different set of facts. You know this case.
She knows it.
You know this
She told me
case.
about it.
It's another case that's very fact-dependent, because what happens in that case, you've got, and Nicole, correct me when I get this wrong, but ministers in a bus terminal, segregated bus terminal, they're in the wrong spot, cops say, you can't be here. And they're like, you're going to have to arrest me, and they do. Well, as you can imagine, this is mid-60s, civil rights laws are coming out, we're starting to get rid of some of this segregated bus terminal stuff. And the ministers are like, hey, you arrested me falsely. I'm suing you under Section 1983. Makes its way to the Supreme Court in 1967, thank you. And the court's like, well, false imprisonment. Remember false imprisonment? Remember that good faith exception? This is a law that was overturned. Police were relying on the law previously established in doing the arrest. And the Supreme Court's like, maybe in that kind of context, there's a good faith immunity. They don't say qualified immunity. They say good faith immunity, and it's a false imprisonment case. But that's where we begin to see how things begun to unravel. Now, one more thing, and I'll hand it over in just a couple minutes here. Two last points that Emma wanted me to say, and I think this sets the stage for my colleagues here on the panel, and maybe some Q&A toward the end. So, one issue with qualified immunity, it's been around for a while. So 1967, it wasn't qualified immunity, but there was an immunity case, and it was sort of the beginning of this thing. You'll hear more about the early 80s Harlow case in a second, where it really gets into it, and then the progression and the Roberts Court, and just the sort of this rolling momentum of terrible decision after terrible decision. But before we get there, the Congress does tinker with Section 1983. I mean, the good news with that is Congress can tinker with Section 1983. It's Congress. They can change the law. And in the mid-70s, on a different kind of case, but it was another statutory case, the Supreme Court said, if you win one of these cases, you don't get attorney's fees, unless it says so in the law. And Section 1983 did not say so. So all the lower courts said, no attorney's fees. Now, those of you who look forward to someday prosecuting civil rights cases, and Paul, I think you'll share this sentiment, it's important to have a statutory attorney's fees provision. It makes cases work a lot better, and a lot of cases don't have significant monetary damages. Well, my point here is that Congress saw what the Supreme Court did, saw the reaction of the lower courts, and said, we got to fix this, and they did. And in 1976, they added a provision that said, you win, you prevail, you get attorney's fees. And again, that was a huge momentum builder for counsel, private counsel, to say, I can perform these cases because there's a statutory provision, and Congress fixed it. Congress has also tinkered with it on immunity. In the early 80s, you'll probably hear more about this, they went in and clarified what judicial immunity might be included. My point is, the good news, Congress can fix, Congress can repair. We'll talk about that, I'm sure, in a bit. The bad news is they haven't. And they've had a long time to do it. I don't think today's Congress is going to have any appetite for it either. But that is certainly one way around it. The other piece, and we'll put a pin in this, and then I'll hand it over, is you heard mention of some of the work that Professor Sisk has done, and Chad has done a lot of this work. We're going to talk about, so far, everything we've talked about is federal court. Section 1983, federal statute, gets you into federal court. But we have state court as well. And in the mid-70s, Justice Brennan, who was one of the more liberal justices at the time, could see what was happening to the court. And a proud alum, Warren Burger, was running the Supreme Court in the 70s, not in a particularly great direction, sort of the beginning of the conservative wave that's lasted since basically Warren Burger in 1969. But Justice Brennan said, you know, we don't have to just rely on federal courts. There are state constitutions, there are state courts. In fact, I'm involved in a desegregation case that's in state court, just to make use of state constitutional law. And so the provisions and the opportunities in state court are another way to think about this. So I raised a lot just to kind of give it some context and to sort of set the stage. We'll have a chance to cover some of this in Q&A, but I want to hear now from Professor Sisk to give us a deeper dive into qualified immunity. I'm sorry. There's moderators. I apologize. My apologies. Paul.
And if you go to law school, you could hear lectures like this every day, and it's worth it. Professor, one of the things that, one of the reasons I'm here is because I've been beaten around the head with the qualified immunity stick as a litigator. When we talk about the history, a lot of times we don't talk about the roles that lawyers have had, either in creating the precedent that makes these things possible, or in failing to fight cases after something happens. If you had to pick a lawyer from that period of history that you talked about, or judge, who would it be? Who would be the lawyer that draws your admiration for either stepping out and making a difference in terms of civil rights, or goes down in flames making a difference for civil rights?
That is an interesting question. Well, the first name in my mind, and probably most people's mind, although it's not necessarily limited to just qualified immunity, although you said quite a bit about it, is Thurgood Marshall. I mean, Thurgood Marshall, it's hard to think, I mean, there's probably arguments to be made for others, but for a more impressive legal career in terms of courage as well as impact. And I don't think you wanted me to go quite down this path, but I don't know of how many lawyers have had to risk their life over the course year after year, literally risking their life. Can you imagine what it was like to be Thurgood Marshall representing death penalty cases in Florida, in South Carolina, in Georgia in the 50s? In fact, just one interesting aside since you've opened the door, Paul. Thurgood Marshall's first civil rights case, by the way, was prosecuting the University of Maryland Law School. Thurgood Marshall, by the way, went where? Howard. Why didn't he go to Maryland? They wouldn't let him. So he found another African-American qualified student after Thurgood Marshall became a lawyer, represented him, and won. And the University of Maryland, thereafter, desegregated. First case was against the law school that wouldn't let him in. A good lesson for law school administrators. But yeah, I guess I'd start with Thurgood Marshall.
With that note, we can end. Whatever you want to do next introduction.
Sounds good. Yeah, so why don't we get more into qualified immunity, what it looks like, what it's evolved into. So we'll hand it over to Professor Sisk to build off of that excellent foundation about Section 1983. I'm going to turn the projector on, so I apologize.
Which is why I'm stepping out of the way.
You guys.
I'm guessing I should move.
Or take shadow puppets.
I'll grab one of these seats while the projector is running.
The question is how much do you
Here's
usually
the
see?
seat.
Thank you very much. Thank you very much. So thank you very much for inviting me here. You know, life is an interesting journey. To find myself as an old-style Reagan Republican, increasingly speaking about qualified immunity and suits against the federal government for wrongdoings by law enforcement officers and representing prisoners in court. It's an interesting journey. I don't actually think I've changed any of my principles. I've just found another way there, as my friend from the Institute for Justice, which does such great work, and I've worked with him on many things. But apparently I'm starting to look the part. Just last week, I was in the Lund's grocery store up on the corner, and a person came over to me and said, "Are you a civil rights attorney?" I said, "Well, actually, I do a little bit of that." He said, "You look like a civil rights attorney." So apparently I look the part. This is also really good timing for me for a couple of reasons to talk about this tonight. One is Jonathan was very generous in giving the lengthy list of things, but there's a new one. I am an advisor to the new restatement on the law of constitutional torts. So how many of you here are law students or lawyers? Raise your hands. So you may not be as familiar with the American Law Institute, but you're familiar with what they do, because you're familiar with restatements of contracts and restatements of torts. They're creating a new restatement on the law of constitutional torts, and one of the primary factors there is qualified immunity, and that's going to be a huge problem for us. Because the role of a restatement is not to try and predict where things are going, but to accurately state where things are, and yet there's a lot of confusion. The other reason this is good timing is because of a case that I worked on in the appellate clinic before the Ninth Circuit this past year. So our client was driving his car in North Las Vegas and was pulled over by law enforcement. Turned out that someone had called and said they thought they had heard gunshots, and they saw a car driving away from the scene. Didn't have a driver's license, didn't have any description of the driver, but they described the make and color of the car. My client happened to be driving a car of that make and color, so he was pulled over. They asked him for his driver's license, and he admitted, I don't have a valid driver's license. So they took him out of the car, handcuffed him, and moved him aside, patted him down, no weapon. The other police officer went back to the car, opened the door which he had closed behind him, and searched the car, finding a handgun in the center console. He was surprised it was there. It was his girlfriend's car. He didn't know she left a gun in the car. But as it turned out, he had, about a decade earlier, a felony conviction, and so he's arrested for felon in possession of a firearm. Was convicted and sent to prison. After 2.5 years, the Nevada Supreme Court finally heard his appeal and decided it was an unconstitutional search. That under a case called Michigan versus Long in the Supreme Court, if there's no probable cause, and there certainly wasn't probable cause here, there was articulable suspicion, they can only conduct a sweep of the car if they have a reason to believe, one, that the person has immediate access to the car. Remember, he's handcuffed, been removed from the car, told you're not getting back into it because you don't have a driver's license, and that they have a basis to believe that he was dangerous, which they had no basis for. So the Nevada Supreme Court reversed. He brought a Section 1983 suit, and that was the basis for this. Now, was the first prong of qualified immunity established, that there was a constitutional violation? Yes, the Nevada Supreme Court had said his constitutional rights are violated. But of course the defendant police officers raised qualified immunity as a defense. But here's where it ties in even closer with some of the things you're talking about. He had had the foresight to not only bring a Section 1983 claim, but to bring a claim under the Nevada Constitution search and seizure provision. The Nevada Supreme Court held that there is a direct cause of action under the Nevada state constitutional provision and refused to imply qualified immunity. So a claim under the Nevada Constitution, and search and seizure provision in Nevada is essentially the same as the federal provision. And in fact, the Nevada Supreme Court had said in this case it was a violation of both the Nevada Constitution and the federal Constitution. Qualified immunity is not a defense. That's one of the reasons why we were able to achieve a very good settlement. About a week before the oral argument, the defense decided they did not want to argue this case. So my poor students lost the opportunity to argue before the Ninth Circuit, but the client will be receiving, once the City Council approves it. So let me talk about qualified immunity and begin with categories of immunity, and Jim talked a little bit about this. The one that we're going to focus on is all the way down near the bottom, second line from the bottom, second column over to the right. Historically, states are immune, so you cannot bring a Section 1983 suit for damages against the state. You can seek injunctive relief against a state officer, which effectively is the same thing. Legislative and judicial functions are absolutely immune.
Professor Sisk,
Yes.
could you explain for people who don't have a law background what are damages and what is injunctive relief?
Sure. Damages is money. Damages are where you say, I want to be compensated for the harm that I have suffered, either the harm of the constitutional wrong itself or some other loss of earnings during time that one was incarcerated, things along those lines. Injunctive relief is where you're trying to prevent the government from doing something wrongful before they have done it. So another way to think about it is roughly damages are retrospective, compensating you for things that have already happened. Injunctive relief is prospective, preventing things that happen into the future. A Section 1983 suit that seeks injunctive relief against a federal or state official is not subject to qualified immunity. So preventing the future harm cannot be defended by a qualified immunity defense. It applies only in the context where you're seeking damages because in theory, although I'll get to in a moment, it's very much in theory, this is personal liability of the individual government employee. And so that's the theory behind qualified immunity. So, and by the way, I should attribute this to a friend of mine at the University of Michigan Law School, Christopher Walker, who I've debated with. He's in favor of qualified immunity. So I want to give credit to him for this slide and for the next one, in which he sets out the three basic arguments in favor of qualified immunity. These are policy arguments. I'm going to get into the history here in a moment. I just want to kind of lay out what we have. So the reasons for the immunity are basically break into three categories. First, the argument is it helps governments hire, recruit, retain people because it can tell them you are not likely to be held personally liable for any wrongdoing unless you act in a truly, obviously incompetent and unreasonable manner. Second, it allows officers to focus upon doing their duty, doing what it is that they've been hired to do, rather than being distracted by being subject to lawsuits. And third, it prevents officers from being chilled from making tough decisions, and so they faithfully execute the law because they're not afraid of the possibility of personal liability. So just to lay out there, these are the reasons why the courts have found qualified immunity to apply. So, what is qualified immunity? Qualified immunity is where the court believes, this is the Harlow case that Jim referred to, that the balance between the evils of abuse of office and chilling the officials and the social costs of litigation is to give qualified, not absolute, but qualified immunity to an officer. And the test is stated in Harlow, and we'll see this test has become very hard to overcome, is whether the official violated clearly established statutory or constitutional rights of which a reasonable person would know. There's a lot going on in that sentence. Some of it is fictional, and I'll get to that later on. So, defining it. Again, the test is whether a reasonable person would know because these rights have been clearly established. I'm not going to read all of this to you. You can read it for yourself. What essentially the court later is saying is if the police officer, the government official, reasonably misapprehended the law, they cannot be held liable for a constitutional tort under Section 1983. And so the focus becomes on whether they had fair notice. And that fair notice is to be measured by the state of the law at the time that the conduct occurred. And understand that by clear notice, we're talking about precedential decisions by courts. The circuits are not in all agreement as to what counts. Everyone agrees Supreme Court decisions count. Most circuits hold that their own circuit decisions count. The Supreme Court has never said that circuit decisions count, so it's not clear whether circuit decisions count. But in any event, it is court decisions that count. So, this means that the precedents that govern a particular point must place that legal issue, as the Supreme Court has put it, beyond debate. In addition, it's not enough that the legal issue be placed beyond debate. The facts of the current case must be something that looks an awful lot like the facts of the case that had been decided previously. If the facts are different, then it is likely that the court will say fair notice was not given. And the Supreme Court has said time and time again, it is not enough to state a general proposition that this type of activity is or is not constitutional or wrongful, it must be particularized to the facts of the individual case. So again, you need to find an analogous case that counts as clearly established law, and analogous in terms of the facts of the case. And as we will see here in a moment, small differences in facts increasingly make a lot of difference. All right, so that was a brief primer. Now I'm going to talk about what's wrong with qualified immunity, and that'll get a little bit more into the detail of this. So in my view, there are 4 things wrong with it. It's bad history, it's fictional, it's dishonest, and it's unjust. And so let me talk about each of these 4 factors. So in terms of bad history, and Jim talked a little bit about this, there is no historical basis to justify a qualified immunity defense to a constitutional tort claim. So, as Will Baud at the University of Chicago has pointed out in his research, at the time that Section 1983 was enacted, there simply was nothing in the common law. Before Section 1983, there were, of course, tort claims that could be brought under state common law theories against government officers, and there was nothing that suggested qualified immunity existed. It simply was not there. There was nothing there. Alex Reinert, who's at Yeshiva University, Cardozo Law School, has pointed out that there is a phrase in the original language of Section 1983 that mistakenly got omitted when the statutes were put into the code in the early part of the 20th century. It originally contained another phrase saying, these constitutional rights are viable in any state law, statute, ordinance, regularly custom, or usage of the state to the contrary notwithstanding. In other words, any kind of common law immunity was being set to one side by Section 1983. Now this is something that law students would be somewhat aware of. Before the 20th century, about the middle of the 20th century, statutes were not organized very well. Statutes were simply in books that were primarily in chronological order, and so it was very hard to find things. And so Congress decided it would be a good idea to organize them together into codes, hence the United States Code. So now, when you talk about Section 1983, that's Title 42 of the United States Code and Section 1983. And so Congress took these statutes and put them into organization as codes and then enacted the codes. Now the codes were not supposed to change the substance of the underlying statutes, it was just supposed to reorganize them. But mistakenly, this phrase got left out when Section 1983 was codified into Title 42. And so Alex Reinert says that doesn't mean it's not still there. Congress never meant to overturn that, and this is further evidence that historically there was no basis for qualified immunity. So, if we go back to the 19th century, before there even was a Section 1983, there were suits against government officers. That was very commonly done, including federal officers. Federal officers could be sued in tort, even though they were federal officers. If a federal officer committed a wrong that qualified as a common law tort, assault and battery, there are a lot of these cases involve wrongfully stopping ships at sea by military crafts that would stop a ship and saying you're violating some law about the transportation of goods from one place to another. And the tort law was available. And the Supreme Court recently acknowledged, yeah, that's true, that's part of how this works. And the way it worked, when the tort claim was brought during the 19th century, there was no qualified immunity. Justice Story, who is one of the most famous justices of the Supreme Court and wrote a lot of treatises, points out here that the rules of law, that a federal officer has to follow the law, applies, and they have the same duties as a private agent, unless they can point to some sort of constitutional or federal statutory justification. If they have wronged someone, the fact that they say they acted in a bona fide manner, that the captain of the naval vessel said, the president told me to stop this ship and to seize it and take it back to port, How was I to know that later on the courts would say that that federal statute that allowed stopping that ship was invalid and didn't apply to this particular ship? I was acting in good faith. And Justice Story says, doesn't matter. The officer is still liable. Now, that didn't mean that the officer really paid the damages. It was well understood that officers who were held liable would be reimbursed by Congress. They would be held personally liable, but then Congress would fill in and reimburse them. So they weren't really being held personally liable. Congress was ultimately doing it. So, qualified immunity has no historical background. Second, it's fictional. The basis for it, again, is there a court precedent on closely analogous facts that clearly establishes the law? And if there is, well, then the government officer's on fair notice as to what the law is. Government officers don't read court cases. The idea that police officers are reading court decisions in order to decide what it is that they may do when they stop a car and arrest someone is, of course, ludicrous. And the distinctions turn on increasingly trivial differences between these various cases. Supreme Court again has said that qualified immunity means that the officer can reasonably apprehend what the law is. But what does that mean? Is it really the case that people read Supreme Court decisions? Now, you're an unusually informed, intelligent, and educated group. And I'm willing to bet most of you don't spend a lot of time reading Supreme Court decisions. Instead, you probably hear about them on the news or you read a summary of them. Frankly, unless it's in my area, that's what I often do too. I don't read every decision that the Supreme Court issues on a tax issue, for example. But I'm supposed to know what those are, I guess, in order to, because ignorance of the law, of course, is no excuse. So, Joanna Schwartz at UCLA has looked into the police training of police officers to see, so how much are they talking about these court decisions that are supposed to be telling them what it is that they are and are not to be doing, and discovered that that's not what they're doing at all. That these training programs are not being informed by close study of court decisions. So the idea that qualified immunity protects officers because they have reasonably relied on a court decision is fictional. Moreover, it's become so focused on minor, small differences between one case and the next that it's difficult to see that any decision really provides sufficient notice to avoid qualified immunity. I like what John Jeffries at Virginia puts it. It's as if there's the old story that we talk about in law school that every dog gets one free bite. Because before that you didn't know it was a dangerous dog, but once they've bitten somebody, now you know that's a dangerous dog. And he says, so the one bite rule apparently starts over every time the weather changes, that's something that makes a huge difference. So let me give one example of that, a case from the Sixth Circuit. A burglary suspect was being pursued by the police and he was sitting on the ground with both of his hands in the air to surrender. The police unleashed a dog on him, which injured him by biting him. He claimed that prior decisions clearly established that a surrendering suspect may not be subjected to a dog attack. And the court said, but in the prior case, the suspect was lying down while surrendering, while this suspect was sitting. And the dog in the prior case was untrained, while this was a trained dog. And so therefore, the facts of this case are sufficiently different that the prior precedent does not apply, did not provide fair notice, and therefore qualified immunity is not set aside. Qualified immunity is dishonest. It's designed to protect government officers from being punished for making reasonable mistakes by being held personally liable. But the reality is, none of them are held personally liable. That's not the way that it works. So Joanne Schwartz and James Vander, Alex Reiner have done empirical studies showing that almost invariably, well above 95%, more like 99% of the time, if a police officer is held liable in a Section 1983 suit, no matter how egregious the wrongdoing might have been, they are reimbursed by the municipality, by the county. No money is coming out of the pockets of individual law enforcement officers. So it's dishonest to say so. But it's a dishonesty that makes a difference. Because when these cases make it to trial, if they get past qualified immunity and make it to trial before a jury, the jury is not told that the officer that is standing before them is not really at any risk of any personal liability. They are not allowed to be told that. So they assume this poor police officer who made this mistake is going to have to pay tens of thousands of dollars, which of course then makes them more sympathetic to reducing the amount of the damages. They are never informed that in fact that officer is not at personal risk of liability, and in fact have been provided an attorney by the government, and the government is going to pay it. So that brings us then to the justice issue. Qualified immunity covers even outrageous wrongdoing. Even if a police officer has violated the policies of the police department or has violated state law, they can still get the benefit of qualified immunity if they can argue that the constitutional parameters of what they did had not been clearly established. So, let me give you a couple of examples of this. The Jessup case from the Ninth Circuit. City police officers had a valid search warrant, went into the individual's house, and stole more than $150,000 in cash and $125,000 in rare coins. This was not part of what was to be seized as part of the search warrant. It was just outright theft. The victim brought suit against the officer saying this is a violation of my constitutional rights under Section 1983. And the court said, well, it was morally wrong for them to steal this money, but they did not have clear notice that stealing money would be a violation of the Fourth Amendment, and therefore were not placed on notice that what they had done was unconstitutional, qualified immunity attached. Or another case, which I was the attorney in this case before the Ninth Circuit. Correctional officers were listening to this prisoner's confidential telephone calls to his attorney. As it happens, this is the third case that I've handled on behalf of a prisoner when correctional officers were reading the prisoner's mail to their lawyers or listening in on telephone calls. And the officer said that they were doing this just to determine whether it was a proper legal call or not. The person who was listening to it said, well, I would listen for words like you might hear in a TV show on law as to whether they were saying those words, and I didn't listen beyond that. There's evidence that they listened to every single word of it, and in fact they had spliced in a cable into the telephone wires and set up a speaker in the area where the correctional officers were so that they could listen to all of his telephone calls. So he brought a Section 1983 suit pointing out that there's a Nevada state statute that specifically, explicitly prohibits correctional officers from listening to telephone calls by lawyers. But the Ninth Circuit held it did not violate a clear Fourth Amendment time that was established at the time that this occurred. There's another aspect of this case that's important to understand as well, because it goes to one of the questions that Emma produced. In this case, the majority of the court said, we are not going to decide whether this was a violation of the Fourth Amendment. We are not going to address the merits of that question. Instead, we're going to jump past prong one to prong two and say, well, the law wasn't clearly established. So the result of it is not just that the prisoner lost, that the lawsuit failed, but there still is no precedent as to whether listening in to telephone calls is a violation of the Fourth Amendment. Fortunately, we had a dissent that said, I agree qualified immunity attaches here. The law, in some ways, had become more clear after this episode, and so those cases, of course, don't apply retroactively. But I think we at least ought to address the question, and this clearly is a Fourth Amendment violation. But that's a dissent, or sort of a concurrence, and the majority of the court decided we're not even going to address that. And by the way, this is the way most of these cases go. In most cases, if there's any doubt at all, what the court does is it avoids deciding the constitutional question in favor of deciding that qualified immunity attaches. And one of the results of that then is we don't learn anything new about what are the limits, the constitutional limits on officers. If the court at least addressed the first issue and said, wasn't clear before today, but we're making it clear now. This really is unconstitutional and should not happen. We're going to apply qualified immunity, so the plaintiff is not going to collect damages in this case. But we are announcing prospectively that this is what the law is. We would gain something in our understanding of the constitutional limits, but that is not the way most courts do it. Most courts jump immediately to the second question. So I've taken up a lot of time. Let me just close by a couple of points here, which is an alternative approach, which I think can apply in a lot of different ways, would be to say, let's quit pretending that we're holding individual officers personally liable. Let's go directly and allow for these claims to be brought against, in this case, the federal government. I was dealing with a Bivens issue particularly when I put the slide together, because these public employees are really agents of the government. In fact, they can't even be sued under Section 1983 unless they're acting under color of state law, so they're clearly acting as agents of the government. And that's of course what makes a constitutional dimension too. Otherwise, it's just wrongful private behavior. So perhaps one approach to this would be to eliminate qualified immunity, but then impose the liability directly on the government unit.
Indemnifies at least pretty much all government officers, but certainly police officers in Minnesota by statute, that every one of those arguments completely falls on its face once officers know they're not going to be held personally liable.
That's simply the fact, and the empirical evidence shows that it's true. Now, I suppose I should, to be completely honest, say that almost every government unit includes some language somewhere saying we reserve the right not to compensate, so they always leave themselves an out, I guess. But the reality is that just never happens. Even when it involves an unconstitutional shooting, for example, in violation of the Fourth Amendment, even if the courts were to determine it really was unconstitutional, the use of deadly force was not merited under Fourth Amendment law, it was a violation of the constitutional rights of the individual who was shot, whether they survived and seek damages or died and a wrongful death claim is being made, invariably the governmental unit pays the damages, not the individual officer. So,
I do have one more question.
Sure.
Because we could get into Manel liability and why that's, we go in for hours.
what he's talking about is he's trying to hold the municipality or the police department directly liable.
And they've got their own second set of defenses.
Right.
In terms of what you have to prove. But once again, I don't want to write the lawyers out of the history, so present company accepted. Who's your lawyer to admire?
You know, I was thinking about that when you asked the question of Jim, and my answer is none of them. Or at least if I'm talking about the members of the Supreme Court, I would say none of them. You know, I'm quite an admirer of Thurgood Marshall as a warrior at the bar. I don't think he was a great judge, and I don't think he's remembered as a great judge. And while there certainly were judges during that time period who opposed qualified immunity, the reasons for doing so tended to be policy-oriented rather than focusing on what the history of this had been, what the text of the statute said. Now we're getting to a point where there are members of the court that don't neatly fall into conservative and liberal categories who have said, we may have made a mistake with qualified immunity. This may be something that the courts have really made up and is not consistent with what the history and the text of the statute are. Now, whether there's enough on the Supreme Court to do something about that, I don't know. But one of those has been the most consistent voices about that has been Justice Thomas, who has said, he was the author of the opinion that I mentioned, where he said common law claims are brought against federal officers well into the 20th century with no qualified immunity being available. And he has dissented from denial of certain cases, saying we should take another look at this. Will Baud may be onto something here that the history does not justify. If there is any immunity, it certainly should be something that was rooted in history and not this strange doctrine of qualified immunity we've made up over the last 50 years.
impacted some of the ongoing litigation and legislation around qualified immunity. Before we kind of get into the work that Chad's going to talk about, I do want to acknowledge that we have a lot of families who have been impacted by police violence, either in the room with us or on Zoom. And this is, not just legal doctrines to them in cases, but it's, real life and real pain and real trauma. I want to recognize that we have a family who started a group here called Impacted Siblings Take Action. And that has been led by Tiffany Burns, who is the sister of Jamar Clark, who was killed by the Minneapolis Police Department here in Minnesota, in Minneapolis. And this year will be the 10-year anniversary. And I just want to acknowledge Tiffany and the work that she's been doing to organize families here in our state. On that note, going over to you, Chad, can you talk about some of the qualified immunity cases that Institute for Justice has taken on, maybe some related to Minnesota?
Yeah, sure. So I'm actually glad that you just let in with that, because one of the things that I wanted to say is I wanted to share a couple of cases that fall a little bit outside what people generally think of when they think of qualified immunity. But anytime I do that, I always want to lead with, I don't want to avoid getting into the qualified immunity is absolutely a roadblock to justice for people who have suffered the most. And those cases generally involve police violence and police abuse or murder, because those are the government officials who regularly carry firearms and who use deadly force. But there's one case in particular out of Minnesota that I wanted to highlight, because I think it's very easy to get focused on the police abuse aspect, and while that's the primary and most dangerous or impactful risk of rights violation, losing the right to your own life, there's an opportunity, I think, to expand the discussion around qualified immunity to pull in people who may not think that they care that much about it. And the reason I mention this specific case is because it's not something that you would generally think of as a civil rights case at all. So one of our clients in Minnesota had bid on a road construction project, and part of that project involves hauling lots of gravel in large trucks. Well, a traffic engineer in Minnesota decided that they didn't want those heavy trucks on their particular road and kept lowering the legal weight limits that you were allowed to drive on that, to the point that some pickup trucks and large vans couldn't even technically go through there. The construction company had an empty truck going through that area. The traffic engineer got so incensed that he personally drove his vehicle out there, blocked the traffic, and then started calling every police officer and every agency you could think of to get somebody to come out and cite these people. To their credit, the sheriff's office said, "You're nuts, you're wasting our time, we're not going to do that." He called tribal police, who were very confused and said, "We don't have any jurisdiction over this matter." And finally, a state police officer, to mollify the traffic engineer, came out, provided a citation, and then called the construction company the next day and said, "By the way, we're dropping the citation, that was ridiculous." Again, I share that story because even that ridiculous set of circumstances where a traffic engineer is essentially acting under color of law, but well outside the authority that anyone would ever imagine a traffic engineer having, to detain someone and then try to create a situation where someone could be arrested or have their property confiscated. That made it to the 8th Circuit, where the traffic engineer was granted qualified immunity. And an unfortunate description of the current state of litigation in the qualified immunity space, the Supreme Court chose not to hear that case. So again, that's a slightly different case. The good news that I wanted to share is another case out of Texas, and that was a client named Sylvia Gonzalez. Again, another very bizarre case. This was a woman who wanted to run for city council for all the reasons that you would imagine someone would want to run for city council. Her neighbors were complaining about potholes. They thought there was some corruption going on in the city government. So she took baked goods and she went door to door and said, "You know what, I could run for city council." She got 53% of the vote. She got elected. Things were great. She decided at a neighbor's urging to start a petition to remove the city manager, who was the crux of a lot of those issues, which caused a series of retaliatory actions by the mayor, the city manager, and their friend in the police department. I'm happy to share those details with you, or you can look at the case on our website, but the end result was actually her being arrested for a strange and almost never used law about basically interfering with government activities They claim she stole government documents. In reality, when she was cleaning up her materials, she took her own petition with her that she had printed out and was collecting signatures on. And it made it into her folder and she was taking it home. Now, the good news, and the reason that I finished with that one, is because she did have her rights vindicated at the Supreme Court recently. That was a victory that said, no, it turns out retaliation against those kinds of free speech violations are a serious problem. And I'm happy to go on if you want, but I know you've got a lot of questions, and I'm happy to let you all kind of govern what direction you'd like to go from here.
No, thank you for sharing those two cases. So, you know, one of the things that we talked about today is, you know, how do you get attorneys involved in taking these sort of civil rights claims? Can you talk and speak, and maybe some of the other panelists can speak to this too, about how qualified immunity kind of disincentivizes attorneys from taking cases like the one you mentioned?
Sure, I'll maybe give some brief comments, and I'm sure my fellow panelists will have more to say on that specific matter. I usually try to lead with, I'm not an attorney. Please don't take any legal advice from me. But one of the things that I want to mention is, and I think there's a one-pager for a version of a law like this actually on your table that's been mentioned a couple of times. One of the ways we address this problem, because there's so much inertia to get a case to the Supreme Court and to get the Supreme Court to just flat out overturn qualified immunity, and we're trying, but good luck in Congress, getting Congress to correct the error on their end via statute. There are reform opportunities at the state level like that bill that has a one-pager in front of you. One of the really important parts of bills like those, which create a state-based cause of action, that let you say, you know what, as long as the Supreme Court says qualified immunity applies to this Section 1983 thing, what if I just sue the person who violated my rights in state court under this law, which clearly says qualified immunity does not apply? Gets around a lot of things. And one of the things you can put in a law like that, and that we encourage people to do when they're doing that at the state level, is a specific line that says, and by the way, you're entitled to attorney's fees if you find that your rights were violated at the end of the day. Because again, as I think was mentioned earlier, if you're trying to engage in the practice of law, it turns out you have to make a living somehow, and people whose rights were violated have a really hard time finding an attorney who's going to take their case through all the levels of government appeal that are going to be required to even have a shot at overturning qualified immunity. I don't know if either one of you wanted to add anything on the difficulty of being a civil rights attorney and taking on these cases.
I don't want to overstate the matter, but I quit the practice about the same time John Roberts took over as Chief Justice. And I will say that qualified immunity is a huge barrier to lawyers because of everything involved. There's one interesting piece that has helped recently. And I mean, obviously the video footage of George Floyd's murder, without that, you saw what the original police report said. And we are living in a society now with a lot more video evidence. It makes a difference. We had a pro se incarcerated individual who was beat up badly by two prison guards for the last 100 years that would never have survived. But the video cameras caught the whole thing. I don't want to overstate it, but a lot of times these cases are settled. They don't make it into court very far. We don't have a record of it, really. And so it's hard to know whether we are, in some respects, not entirely, but in some respects, balancing some of this terrible law with some better technology and some quicker settlements. That doesn't make up for it. But I think for lawyers who are thinking about this kind of work, I don't want you to leave here discouraged that it's impossible. And remember what I started with. This comes in cycles. There's enough effort now. I mean, there's a few states that have adopted this. Colorado is one of them back in 2020. Within a month of George Floyd's murder, passed a pretty significant police reform bill. They didn't address immunity very carefully, and right now what they're seeing is some state courts are starting to impose weird other kinds of immunity. But generally speaking, it's been a relatively successful, and we'll see, it's only been 5 years and it takes so long for these cases to go. But there's been some momentum in state court, and I don't know what happens at the midterm elections next year, but when we have a reconstruction agenda ready, because people have been looking at this issue so carefully, people from all sorts of political bends, including Justice Thomas. And in fact, the joke is Justice Thomas and Justice Sotomayor, if they agree on anything, we got to do it, because it's a unique opportunity. So I don't want folks to be too discouraged, but obviously the current state of the law is very challenging for plaintiffs trying to bring police abuse cases in particular.
So I am a lawyer, but I don't want you to take any legal advice from me because I'm not your lawyer. So I'm just offering general comments here. I think it's one of those areas in which certain lawyers who are able to make really good choices as to the cases that they take can make a very good living as a civil rights attorney. The problem is the cases that are more questionable, it's harder for lawyers to be willing to take those because the chance of any kind of recovery is so limited. And that's why those kinds of cases often end up being taken pro bono. So pro bono programs are really very important with respect to this. I see some of my students here who've had me have me in professional responsibility. About 15 years ago, I decided to stop doing consulting work and devote all of my non-teaching, writing, service time to pro bono and focus that on prisoner rights work. These are cases that no one would take. There is no possible chance that you could make a living handling the cases that I have been handling. These are all pro se's that lost in district court, and we're trying to get that overturned in the court of appeal. I will say we've got about a 75% victory rate. But even so, we've only gotten attorney's fees once, and most of that money went to the university, not to me. So there are certainly very well-known, nationally well-known civil rights attorneys who make a very good living, but they also have the option of choosing the best cases that get the most attention. It's the ones where people have a legitimate grievance, but it may not be something that's going to amount to enough damages, or the qualified immunity issues are very strong, that a lawyer would look at that and say, it's just not worth it. One last thing to say about prisoners, it's even worse in the prisoner situation because of a statute called the Prison Litigation Reform Act, which provides that the amount of attorney's fees that you can get is very, very low. So even when you do win, you're not going to get anything close to what your hourly rate is, and it's back to the amount of damages if you got damages. So it's very hard.
Chad, I was wondering if you could talk more about the work that you've been doing, getting these state-based, 1983 claims. Can you just share with us some of the work that you've done on that, and maybe some of the biggest challenges in getting those laws passed?
Yeah, sure. So Colorado has already been mentioned. I think they get sort of credit for being the first, although there are various different types of reforms, so depending on how you count it, you can get anywhere from 4 to 6 states have done something in this space. We were really involved in the New Mexico effort that looks a lot like the kind of legislation that we typically recommend. And very frankly, the recommendation there is cast a wide net. There are a lot of folks that have interests in this category that allow for the creation of some really fascinating and unique coalitions. I mean, I think we were just talking about Sotomayor and Justice Thomas, right? That's the kind of policy space that you can find yourself engaged in. And that's exactly what happened. In New Mexico, you had conservative groups who were concerned about constitutional rights violations, who said the Bill of Rights matters, I care about my Second Amendment rights, my freedom to practice religion, my freedom of speech. Then you had sort of more progressive-oriented groups that were really focused on police violence as a concern. Well, it turns out both of those things can not be solved, but at least addressed by the same kind of approach at the state level. I don't want to make that sound incredibly easy because coalition management is always a challenge, but I do think that both Colorado and New Mexico paint a really positive and optimistic picture for the possibility of doing some kind of state reform in any different type of state. And frankly, Minnesota would be a wonderful place to be the next one to kind of join that list. And kudos to you all for really doing a great job in getting that started.
Yeah.
Can I ask a question about that? I mentioned at the beginning that I'm representing an individual who relied on Nevada's elimination of qualified immunity, which wasn't done by the state legislature. It was done by the state Supreme Court, which determined that the state legislature hadn't done anything that prevented them from doing it, and found it right directly under the state constitution and rejected the idea of implying qualified immunity there. How many people are thinking about those sorts of alternatives? Has any thought been given to asking the Minnesota Supreme Court to follow what Nevada has done? Because that certainly is a quicker way in some respects in many respects, in every respect, than going through the legislature.
Before I jump on that, I just wanted to say, if you are not a lawyer in this room and you don't want to be a lawyer, good choice. Right? We're all kind of weirdos. But there's plenty of work for you to do, whether you want to help with your money or you want to help with your sweat. There is plenty of work to be done for lawyers and not. And as you can tell, part of the business of law, argues with what I think of as the religion of law. We're trying to get justice, and that's our North Star. So if you want to help, there's ways to do that. But if you are either a lawyer or going to be a lawyer, when I listen to these guys, the first thing that comes to mind whenever they bring up an idea is, how can I weaponize that? How can I use that? For instance, you were talking about injunctive relief is immune from QI. So and I can still get attorney fees under 1983 cases. I can go after cities for what they are going to do based on their policy and change the law.
Oh, yeah, and in fact, I mentioned that we did get attorney's fees in one case, and it was a case just like that. This was a case involving a prisoner who discovered that correctional officers, a prisoner on death row, he's become a very good friend of mine, he's wrongfully on death row, but that's another story, I'll save that for another time, discovered that correctional officers were reading his letters as he was sending them to his lawyer. Now, he could have brought a Section 1983 suit and sought damages for having done that, and qualified immunity, of course, would apply. He was smart. He knew what he was doing. He asked for injunctive relief only, which took qualified immunity completely off the table. He wanted an injunction against the State Department of Corrections, the director of the Department of Corrections, to prevent them from reading his mail. And it took 2 trips to the Ninth Circuit, but we got it. And we got an injunction in his favor, and then because we had won, we got attorney's fees, and fortunately there was favorable Ninth Circuit precedent that said you can get a higher rate of attorney's fees if you took a case based on injunctive relief for a prisoner, because there's no damages, and so nobody's going to be willing to take that case except pro bono, so we're going to give you even higher award of attorney. It's still much lower than you ordinarily would get, but so that's actually a decision that people ought to think about. Again, it's not a way to, probably not a way to make a great living, but maybe. But think about it. Do you really want to go the damages route? Because then you get hit with qualified immunity. If what you really want to do is stop the government from ongoing doing something that they're doing, seek injunctive relief, qualified immunity is out the door.
But I did want to react to what your initial question was. On the state level, we have official immunity, which much of the time is coterminous with, but it does not necessarily, that agency relationship with cities and torts claims had a case where we did actually win the 1983 claim for violation of Fourth Amendment rights because they shot him wrongfully. But at the same time, we also won a wrongful death case under state tort law where they held the city liable as well. Ultimately, it makes no difference in who writes the check, but legally it makes a big difference because we're able to hold municipalities and counties liable on an agency theory like we're talking about. They don't get qualified immunity.
You know, I'm really glad that you raised that issue. This is something that particularly, to make this more complicated, at the federal level, there is no Section 1983. Congress has never passed a statute providing for civil rights claims to be brought against federal officers. So it was implied for a while under Bivens, which has mostly gone away, and that's a whole other thing. We could spend the next 2 days talking about that. But one of the things that I've been focusing on is people neglect the tort remedy. And when you're talking about something that is a physical wrong, like an assault and battery, which obviously an arrest, a shooting is, or false imprisonment, false arrest, don't neglect the possibility of bringing that as a tort claim. Now, it is a defense to a tort claim that what you did was legally justified, but that is the question, that they have to show that it was legally justified. And I don't know what the rule is in Minnesota, but I represented one prisoner who brought a tort claim for having been assaulted by a correctional officer. And the reason that he prevailed is because in the state of Arizona, justified use of force is an affirmative defense. So the burden of proof was on the officer to prove that he was justified, not on the prisoner to prove that he was not. And it was a bench trial, and the judge said that made all the difference to me. I would have ruled against him if he had the burden of proof, but burden of proof was on the government, they failed to reach it. So don't neglect the possibility of tort remedies. That can be a very important approach too.
Thank you. Going back to our discussion about kind of the state-based claim, can you share a little bit, Chad, about how can Minnesota be the next state that really passes something like this, and the lessons that you've learned from New Mexico?
Sure. So I'm actually going to co-opt the point I think you were making about the kind of blood, sweat, and tears equity that goes on to whether it's bringing cases via litigation or whether it's doing changes via legislation. So one of the big things that I do on this issue is work with Institute for Justice's Americans Against Qualified Immunity, which is AAQI. I think there's some literature on the table about it. And it's a grassroots effort to try to mobilize and educate people on this issue. We just had the benefit of 2 master classes on the history of Section 1983 and what that's turned into as qualified immunity. It may surprise you to know that outside this room, lots of people still have no idea what qualified immunity is. It's much better than it was before 5 years ago, when there was effectively a very justified sense of righteous anger in the country that caused a lot of people to learn about this issue. But there is still so much ignorance about what qualified immunity really means. And helping to explain to people beyond the history, which is important for us to know and grasp and then get to, and this is why it's a roadblock to justice, is such a big part of getting something across the finish line. So here in Minnesota, a lot of the hard work luckily has been done in that there is very reasonable legislative language that could move forward. And now a lot of the next steps are getting the word out, getting letters sent to your state lawmakers, calling your state lawmakers' offices, building those coalitions within your own social networks, within your own communities, finding people who might not be interested in a lot of the other issues that you're interested in, but you say, hey, what would you do if the government took away your right to practice religion? How would you get some kind of relief or justice from that? I bet you didn't realize that you might not be able to sue them in court. In fact, one of the things we often do when we go to conferences on this issue is there's a big placard behind me that says, did you know you can't sue? And then it's just a sort of a smattering of government officials everywhere from IRS agents to your local sheriffs. Because again, a lot of people just aren't aware. So being part of the grassroots movement to educate other people about the role that qualified immunity specifically plays, whether it's in police accountability or constitutional rights accountability in general, is a huge component to that. I understand that in the state of Minnesota right now, the legislature is having a very interesting year. There are ties involved. There are questions about when the session officially started. So it's a challenging legislative session, but I don't want that to discourage you. And I also don't want you all to think, well, we'll just wait until next year. Because a lot of times what will start happening is even at the end of legislative sessions, when your members start getting phone calls from their community, that gets them thinking about it. Then when they go to conferences in the off session or when they're meeting with constituents at town halls, they see you all, they hear from you all again and again, they start to think about the issue. And then when you show up at a Capitol Day next year, hopefully with someone who's already pre-filed the bill and it's on their table when they walk into session at the beginning of 2026 or whenever it happens, they're ready to engage on the issue because lawmakers need as much education as we all did when we first heard about this issue. And it's very easy to overestimate a lawmaker's familiarity with qualified immunity as well.
In fact, Jonathan will remember this when I testified before a House committee. One of the opponents of the bill announced to everyone, there's no need for qualified immunity because if a police officer doesn't follow the rules of the department, they don't get qualified immunity. Dead wrong. That is simply not correct at all. And so don't assume that the legislators themselves are aware of what qualified immunity means and how broadly it sweeps even outrageously illegal conduct within the scope of immunity.
I got pretty excited by two things Chad said. And I know this is controversial to say at a panel discussion about police reform, but the two ideas that give this a real shot, bipartisanship, just for bipartisanship, is so meaningful these days. I mean, I didn't mean to make too much of a joke about Justice Sotomayor and Justice Thomas, but the reality is we can't do anything across political lines right now. But here you are. I think the political leanings of this panel are a good example. This is an issue that could demonstrate some way of people working together across political lines. That's a huge step towards a more meaningful democracy. So I don't want to lose that really important point, Chad. Thank you for making that. And the second one was, and this is controversial, I'm not even sure I want to say it out loud, but I just want to play with the idea for a second. Maybe this isn't about police reform. Maybe this is about all those other issues that Chad mentioned to try to bring in other folks. Because as Emma's very well researched and written master's thesis points out, there's a powerful, powerful organization opposed to qualified immunity, the police unions. Those associations are tough. And so you announce, hey, I got a police reform bill, automatically you got trouble. I've got a bill about government employees violating constitutional rights and trying to remove barriers to bringing those lawsuits, and I can make it bipartisan. That feels like a little bit more momentum. It's a way of getting done the work without maybe politically sinking it too early.
Thank you. Despite my organization, we're going to run out of time, but I do want to open it up to any of the audience to ask any questions. Yeah.
Has anybody considered bringing an action against the publishers of the U.S. Code to get those 16 missing words restored?
Yeah, that's a really good question. Part of the problem is that the code was then enacted by Congress, and so that makes it's a really difficult question.
So you'd have to amend, not just say, wait a minute, you
1874
you messed up.
It's uncertain about that. I think Alex would say no, it's still there because the code reviser promised they weren't changing anything substantive, so we should read it as still being there. I think the best hope for it is I know that there have been a number of federal judges who have become aware of this and have even mentioned it in opinions that this is
It's some Supreme Court opinions that there's 16 missing words.
Yes, and so I think the stronger way for it to make a difference is that it strengthens the historical argument that qualified immunity has no historical founding. That even the missing words of Section 1983 confirm that Congress never thought that something new and imaginary would come up. So I don't know that we can get the words added back to 42 U.S.C. Section 1983, but the importance of it is still there, and it's being recognized increasingly by scholars and mentioned by judges. And I know of judges in the district court in Minnesota who haven't said it in an opinion, but they've told me that they are aware of the issue.
I've been hoping to put that issue in my next post misconduct.
I like the way you think about that. Awesome.
Any other questions? Yeah.
Hello, I'm Lee McGrath. I'm a retired attorney, and I previously worked with Chad and some of my friends here at the Institute for Justice and have lobbied for the state-based 1983 act that Chad has talked about in a number of states, including Minnesota. One of the things that I included in IJ's model bill was the codification of Graham v. Connor. I thought that was a fair concession to make to police. I wonder if you might comment on whether you think that's a good idea or not.
I'll do the easy part, which is just to kind of give like the quick overview and let you all provide substantive opinions on the question. Graham v. Connor, best understood as just saying there are things beyond qualified immunity that protect an officer who's doing a search or doing their job in the heat of the moment. And courts should take the position of what a reasonable person in the moment would do, rather than think in hindsight and try to judge from the safety of their courtroom bench how that action might have unfolded.
I think it's another example of how qualified immunity becomes a little bit redundant, because the Fourth Amendment refers to a reasonable search. So there already is, it doesn't have to be a perfect search, it has to be a reasonable search. Of course, it takes into account the circumstances and whether there was danger at the time, and all of those factors come into play just in determining whether it was even unconstitutional. You don't need the additional play of qualified immunity. So the sorts of things that you're talking about there, we do have to give a lot of discretion to police officers and recognize that they're acting in dangerous circumstances sometimes with people who they fear are a danger. And but the Constitution already gives them that protection on the front end. They don't need yet another layer of immunity afterwards in order to be protected from being second-guessed in a difficult situation.
I would add two other pieces. And I think in the case of use of deadly force, I think two additional things might bring some additional precautions. First, what do they do before the moment where they have to make this decision? And I think if officers realize that the law requires some work to avoid getting into that circumstance, that would go a long way. That's number one. The second is, and this is related, but de-escalation. And a lot of police forces are actually doing this. I mean, if you look at some of the more progressive codes among even big city police departments across the country, they already recognize, and I hate to put it like this, but this is how sometimes the officials will think. They're spending hundreds of millions of dollars in settlements, and they believe that it is a small number of officers. They're not ready to admit it's a culture issue, but at least they're ready to admit that there is a problem. And if they don't guide those situations, particularly the use of deadly force, with additional precautions up front, then I think we get into this situation of it was a split-second decision. And it's not. It's a decision that leads up to that split second. What are they doing in advance? What are they doing to try to avoid it? And I think we've got to codify that.
I agree, and we have introduced a bill that didn't get traction this session, but we're hoping to get it again, that would do just that. And so we just, in 2020, we changed our use of deadly force bill. And one of the things that we want to amend now is putting exactly that. We want to say that the officer should, the reasonableness of the officer's decision to use force should look at whether or not they increase the possibility that they would have to use deadly force. And then we also want to require them to use de-escalation when necessary. And so that's another one of those. I like the idea about having a reconstruction agenda, and I think that our state-based tort claim as well as that bill will be part of it. But Chad, do you have something as well?
Sure, I'm mostly just going to steal that excellent point to get on a personal soapbox that I think is really important in the qualified immunity conversation, particularly if we're in the context of suing or holding liable the government employer. Because often what I will hear when I suggest that to folks is, well, then where's the accountability for the individual officer? And so I always encourage people two things. One, to really think about that culture shift that we're trying to institute within a government department by making the government department liable and responsible for these, so that they have better hiring practices, so that they're training properly, and they have better firing practices, which is just as, if not more important than the other two. And then when you mentioned the idea of breadcrumbs, it also reminded me of something else that I think is important here, which is that a lot of these cases that end in settlements because a horrible tragedy has taken place, and frankly, elected officials have been shamed into finally doing the right thing because they can't hide from it because of new technology. Those don't come out of nowhere, and often there is a trail, whether it's because of the department or whether it's because of the individual. And if you can open the doors of the courtroom to those smaller cases that don't have the benefit of something tragic happening that goes viral on Twitter or Instagram, you develop the record that, again, lets the department hire, train, and fire appropriately, so we never get to the horrible thing and no one ever has to have the loss of life lawsuit that's a result. I just think it's very important, if you're talking about qualified immunity, to really think through what is the chain of accountability and how does the specific policy reform help you get from A to B.
Thank you. Yeah, just to kind of add on to what you guys were saying too, and a note to maybe some of the law students in the room is that there are ways that you can cut around the corners of these issues, and that's some of the work that my godfather and my godmom have been trying to do with the work that we do, is that we've taken on cases where, individuals were had their roommate killed by the police, and then they were imprisoned in a squad car for hours on end despite being asked to be let out, and then we were able to represent them and get a settlement. But more importantly, we said in the settlement that we want a policy change, that now the department has to be trained about you can't hold people wrongfully in a car. And so we've done some of that work, but then we've also tried to take on some of those cases that Professor Sisk was talking about earlier, the ones where it's more questionable. For example, we took on the case of Cordell Handy, who he was killed by the St. Paul Police Department, and what the officers originally said was that, Cordell had shot 16 times in his apartment building, he fled, police followed him, they followed him down the street. He pointed a gun at an officer twice, and so the officers had to shoot him. And there was no body camera footage at the time, there was no nothing. And so, what we did, and what mainly my godmother did with the reinvestigation work group, is that she poured over the physical evidence and said that, and we also found some witnesses who refuted what the officer said, and we interviewed these witnesses who had never been interviewed by police, and what they said was that his hands were up at the time that he was shot. So we hired a forensic expert, and he, validated what Nicole had found, and that he had been shot in his hand, and there's no way he could have been holding a gun with the extent of his injuries. And so I think this is just like a message to young law students and to other families too, that just because somebody says something about your case doesn't mean it's the end. Just because an attorney won't take it at the beginning doesn't mean it's the end either. Especially some of those big attorneys across the country, that's not the end of your case. You just gotta find some, weirdos like my godparents, or like some of the other attorneys in the room.
Can I add briefly? When you're a new lawyer and you're deathly afraid of embarrassing yourself, so you do the same things that people before you have done, that's less than you can be. You need to do what you think is right. Find the way to do it. Yeah, that's just weird. I wonder if I can find a way to make it work. Find ways, like I said, if I hear it, I want to weaponize it. I want to find a way to make it work, to get it to work for justice. And that's the only real ambition if you're a law student. If you want to get a BMW and a Rolex, I got no time for you. But if you want to get justice, there are ways to do it, and you have to be fearless intellectually as well as physically. It's not, you don't have to worry about them shooting in a parking lot necessarily. You just have to not care. What's the family song? I don't give a damn about my about our reputation. That's what you need to do in order to make a difference if you're a law student. So that's my word to you.
Any other questions from the audience?
I want to ask a quick question for you, Counselor, since you like Thurgood Marshall, about Murphy versus Pearson in 1935 with Thurgood Marshall. Why did you think the 1935 case wasn't popular compared to the 1955 Board versus Brown of Education?
It's a great question. Brown versus Board of Education was the United States Supreme Court basically saying the system of racial hierarchy is unlawful. Now, there are a lot of problems with that case because, as we know, it was 1954 and not much changed because there was a second case that came out, Brown second, that said use all deliberate speed, which basically said don't go very quickly. In fact, take your damn time. And it wasn't really until the Civil Rights Act of 1964 that we saw meaningful change. But what Brown did was so monumental in the shift of our understanding of racial hierarchy I mean, you can just tell from the reaction. I mean, there were states that literally shut down their public schools rather than share their public schools. You think about the powerful message that that sent. White administrators were afraid, so afraid of integrating their schools that they said, we're not going to have public schools anymore. The Southern Manifesto that said, we're not going to abide by this. You want to talk about constitutional conflict? We had governors say, I don't care, we're not doing it. We had to send federal troops to escort little grade school students into schools. So Brown has a special place. And so, you know, if Paul, and I don't think we're going to run out of time, but if Paul were to say, hey, so what's the biggest case ever? I think a lot of people would say Brown. Now, Brown's got problems for all the reasons I said, but what it did in terms of the shift of what we understood the racial hierarchy legal structure, it stands alone.
Yes.
Thank you.
Thank you.
Before Jonathan kind of closes us out for the night, I just want to direct you all once again to the materials that are on your table. You know, if you want to support the work and are able to support the work of the Minnesota Justice Coalition as well as the Reinvestigation Workgroup, please do so. The other two things I want to make an announcement of, it is the 10th anniversary of Jamar Clark's death this year. The family is trying to get a memorial bench created, so if you're able to support or spread the word about that, there's a flyer on your table. Also coming up in July is an incredible event. It's put on by Kim Handy-Jones, who's the mom of Cordell Handy, who we talked about. She puts on an annual banquet each year about her son and also about stolen lives across the country, or impacted families across the country. And one of the things that she does is she gives away headstones to families who have had somebody lost to police or community violence. It's a whole weekend of celebration, and so we really hope that if you're interested in some of the stuff we talked about today, please attend that. It is, you know, absolutely an impactful event. It's here in Minneapolis. It'll be, I believe, about the first week in July, so you can look on the website for Cordell in Remembrance of Me Foundation to learn more about that. And with that, I'll hand it over to Tom.
We want to thank all the moderators and the panelists for their knowledge and wisdom. An event like this takes a lot of people who have helped. I want to thank the students who have helped out in several areas, and their service has been invaluable.